Okay, good afternoon, everyone. You're welcome to the second day of the debates Moot mock bootcamp of the Honorable Justice Innocent Umezulike Foundation. I like the fact that, and I'm taking note of those that came early. It's actually commendable. The early attendees, please keep it up. So this is day 2. I trust that you benefited a whole lot from day 1, where we learned about mastering persuasion and case analysis, case or debate analysis, research and writing. So today would be another beautiful ride, learning about cross-examination and rebuttal tactics, as well as public speaking. So very briefly, I'll just do an introduction of the foundation that is organizing this bootcamp. Then once the facilitator joins, we go straight into the class. Okay, about the foundation. Honorable Justice Innocent Umezulike Foundation is a foundation that was formed, is an international non-governmental organization formed to honor the legacy of late Honorable Justice Innocent Umezulike, who at the time of his death was an acclaimed professor of land and property law. He authored over 25 books and served as Chief Judge of Enugu State, clinching the longest serving Chief Judge in southern Nigeria. The foundation delivers its mission through the promotion of excellent legal education, research, and charity initiatives. Some of our facilities and programs include the Law Library, Legal Research Center, annual lectures, workshops, seminars, educational grants, and funding. About the Moot Mock and Debate Bootcamp 2024, it is an extensive program designed to cultivate the next generation of advocates and orators. This bootcamp serves as a beacon of opportunity and learning, aiming to foster critical thinking, articulate expression, and persuasive communication skills among students from diverse academic backgrounds. Throughout this journey, facilitated by seasoned mentors and experts in the field, you will find a unique platform to not only enhance your skills, but also to forge connections with like-minded peers who share a passion for debate and advocacy. The HJIUF Moot and Debate Bootcamp signifies more than just a training program. It represents a commitment to excellence and a dedication to empowering the youth with the tools and techniques necessary to excel in the arts of persuasion and communication. As you embark on this transformative journey, envision yourself not only as a proficient debater, but also as an articulate voice capable of shaping dialogues and effecting change in your community. Approach each session with an open mind, actively participate in the discussions, and embrace the interactive learning experience. This collaborative journey of discovery and growth holds immense potential for each of you. Once again, I heartily welcome every one of you to the HJIUF Moot and Debate Bootcamp, where the seeds of advocacy and oratory are sown for a brighter future. Our first facilitator for today that will take us on cross-examination tactics and rebuttals respect to debates is Ugochukwu Okocha. Ugochukwu is a dispute attorney at Babalakin & Co., where he works chiefly on dispute resolution matters. He routinely researches and advises on wide areas of domestic and international laws and practices. As a reformative global policy enthusiast, he's building expertise in jurisprudence, taxation, and international economic law. Ugochukwu is the convener of Dear Trial Enthusiasts, a platform where he shares trial tips and strategies with lawyers within and outside Nigeria. He has mentored over 400 Nigerian law students and young lawyers, especially as relates dispute resolution. He was recently decorated with an award as 30 under 30 Rising Star in the legal profession and was a nominee for the Best Young Litigator for year 2023. So he's a member / fellow of renowned professional bodies such as the Society for Advanced Legal Studies, Young Institute for Transnational Arbitration, Young International Council for Commercial Arbitration, Young African Leadership Initiative, Young Singapore International Center, Associate Chartered Institute of Arbitrators, and the Nigerian Bar Association. So it's my pleasure to have Ugochukwu Obed as the first facilitator for today's session. Yesterday, he taught on case/debate analysis, research, and writing. I want someone to just give us a little recap of what you personally gleaned from what he shared yesterday.
Okay, I would just say that based on research and writing, I would just say that it is very important to conduct thorough and adequate research before you can be able to draft documents or draft motion, or like what you need to present your arguments in moot trials. So I learned that research is very, very important before writing out.
Okay, thank you for that attempt. There was something he shared yesterday, like in sequence on how to do your analysis. Can someone help us? He used terminologies. Can someone help us with that if you remember some things that he shared yesterday? I'm very particular about those terminologies he used. Okay, let me give a hint of what I'm expecting. The first one he talked about was the MAD method. And that's order. That's what I am expecting. Okay, good afternoon. Who is speaking?
It's Fatima, I'm speaking. You mentioned that what he mentioned is the Israeli bird approach, the madman stage, the architect stage, the capital stage, and the judge stage.
Good attempt by Fatima. Can someone else now take it up and share what those stages entail? Remember, from what I introduced earlier, this is not just a this is not just to satisfy it is not just for the attendance, so that it will be that you came for the boot camp, so that you will not be in any way affected in the upcoming competitions. HJIUF trainings and competitions are primarily to help you become a better person and, of course, a better lawyer. When you glean from the trainings and learn from the competitions, beyond the win, whether you win or not, the exposure is what you would use in practice and in your legal career. So if you're just coming so that you can mark attendance, that it would be that you came, actually you're not doing yourself. I know these things. I'm a lawyer. This year should be my 9th year post call. So it is not about me. It is primarily about you. Okay? So please do yourself a world of good to maximize the trainings. Please. You're welcome, Ugochukwu. It's good to have you with us this afternoon, and we look forward to the insights that you offer on cross-examination / rebuttal tactics. The floor is yours. You can go ahead and do your thing. Welcome.
Okay, thank you very much, Ruth. Thank you for the opportunity to speak again to this audience. Yeah, so I'll just delve right into it because of time, right? cross-examination, and somehow as budding law students or budding lawyers, we sort of have an idea of what it's really about. You know that when you hear the word cross, it's more of, okay, fine, an opportunity for you to try to put your own case forward or in a better light by trying to look at what has been examined in chief and see how you can either see faults in it because of check for issues as to whether it's inconsistent, if the truths do not align, check for if the person who are giving such supposed truth is not fit and proper to give such evidence, thus trying to puncture the credibility of same. You are looking out for whether just anything you can do to lower or impeach the credibility of that testimony. And there's one, and the way it goes is that if you are successful, it puts your case in a better light, right? So that's just the way it works. So that's correct cross-examination, really. And then the thing is, there are rules governing this thing, right? So first, you want to wonder, maybe you think in this our short discussion, I'm going to be telling you a way to cross-examine, but not exactly. People have their styles peculiar to them, right? So for a very young lawyer, for example, when you start out in practice, there's this thing about being overzealous or sort of zealous, I don't know, and then you have the opportunity to cross-examine, and you just run with the principle that any witness that comes your way, you will crack the witness. Well, then that should not be the mindset, right? So the ideal thing is, in a cross-examination setting, before you even cross-examine first, you would have had the opportunity to do what I call the 80/20 rule. Now, the 80/20 rule, what that simply means is, when you have a case before you, you're supposed to analyze, strategize, and know how you want your case to go. So when you do an initial evaluation of your case, you're asking yourself, how many witnesses do I need to prove my theory? Now, that theory is what you're running with. And it's on that theory that you can even prepare your draft final written address even before you get to your address stage. Because what it simply means is, if your theory works, right, all things being equal, if the theory that you have on paper, if you're able to, maybe you say you need like 5 documentary evidence, you need 2 witnesses, this is the story they have to say, these are the fact that you're going to ensure that your documents are in admissible form, you can have everything thrown in there. You're telling yourself, what are the possible cross-examination questions that they want to have to crack everything they have on paper? Documents speak for itself, after all. So if you have done your strategy, your initial evaluation, your theory is that, okay, even if you proceed to trial, right, if you cannot feel 100% solid that you're going to win the case, at least let it come down to 80%. If at the point where the court is adjourning for final written addresses, after cross-examination, final written addresses, if you're not having to tweak a lot of your storyline, then you already know that you are going to likely go on appeal because your story has drifted. You are trying to adjust your story to look for maybe possible loopholes or any other things you can say in your written address, because you have seen that your evidence did crack during trial. So that is that you need to look out for. How, if you want to cross-examine, if you want to proceed to cross-examination, there are preliminary steps that must have been done first, which is you need to have a case management. This is what I want to achieve. So the objective on ground makes the narrative clearer. It makes the cross-examination smoother. And why this is important is, during cross-examination, because of what we have currently as front-loading system, we have a world where you get to be aware of the number of witnesses that you have to cross-examine. You get to be aware of the witness debate on oaths, that is the testimony of these witnesses that you have to cross-examine. When you go through, first, you should know the factual issues already. When you go through the evidence of these witnesses, you are able to think to yourself, if they are bringing 14 witnesses, do I need to overflog issues on one witness? Or do I need to try to crack all the witnesses? Is this a witness that is coming to say pretty to nothing? Because not all witnesses are coming to really speak to the main issues. They're not star witnesses. So you're wondering, if I start asking questions that I'm never sure I have answers to, does it not open the floodgates? So you have to be very careful. It's not advisable that you ask questions that you don't have an answer to, or a very fair chance to. So, and this is very tricky. So, for example, you have the opportunity of doing a examination to with an expert witness. Let's say, for example, a medical doctor, or let's say a psychologist, right? Or let's say start with a medical doctor, and then you also start talking about things like, let's say, the neocortex. You're trying to discuss some of those terminologies, and he's telling you things that you don't exactly know, like the amygdala. You don't know where the amygdala is in the brain, but you ask the question, and then he tells you the amygdala is on the right side. Who are you to say it's on the left side when you don't even know the answer to the question? So you have to have done your research. So cross-examiners who are successful are people who have done a great depth of research into what they want to achieve. And that goes back to your objective. Your objective, your client is aggrieved, thought of negligence, telling you that this particular oil spilled into his own river. He wants compensation, right? So, I mean, you know that most likely you're going to go up against very top companies like Shell, SPDC, or these NOSDRA, these top agencies. You already anticipate that they're going to call in experts to come and show that truly there was no spill, or even if there was a spill, they are not responsible. You are really imaginative, you are thinking ahead. So you're like, if they're bringing these experts, this is what the expert is likely going to try to establish. What do I have to look out for? You are really saying, you know what, I have to discuss my own experts too. I need to call in experts, run this by the expert. The expert will tell you, okay, fine, these are the things. We have to come up with an expert report or evaluation report to assess the level of damage. You are studying that material and saying, okay, fine, these are things to look out for, right? From your own. Those other people are also going to bring an expert testimony in court that will say something different, materially different from what's your own testimony. But you have to be sure that you're able to cope with some of the fundamentals, which is, let's say, for example, what can lead to an oil spill? That question is very important. What can lead to an oil spill? You get so those very some of those, or let's say, for example, now the expert is a policeman, and some people used to do this when I was in university. I also did it as well. So because section 231 or thereabouts of the, or 221 of the evidence that allows for you to try to impeach the character of the expert of the witness. What I do then was I was asking you, a policeman, I'd be like, your signet, how many stars, what does this star mean, what does this thing mean? I'm just trying to impeach you to know whether indeed you're a policeman, especially when you did not bring an ID card. But I never did that not knowing the answers to them. Because if you told the court that it meant the elephant meant strength, and maybe it didn't mean strength, and I'll be like, are you sure it's strength? I don't have the answer now. You get so you have to be very careful when you want to ask questions like that to impeach the witness. Be sure of the answer. Now let's go a bit further. Now, so the thing is about style. People have different styles. Some people are aggressors. I mean, they are aggressive in court. I can't say don't be aggressive. It's your style. What works for you works for you, right? But don't be too aggressive and then you get too emotional that you cannot even like make sense. Or so you're asking questions. There are arbiters or judges there or juries. They want to follow you. You have to ensure that your questions are such that they are following you, right? If you are losing them, you're not making a case for yourself. And if you are losing them and the witness is able to answer a question in a way that, okay, fine, is sort of making his own case feel better, chances are that you're going to lose that case already. So you have to be very careful. If you're asking a question, ensure it is it's crisp, it is not too lengthy, because if it's too wordy, then even you're not even too sure what you're asking. You want to avoid a scenario where the judge is not saying, counsel, let me understand your question. You want to avoid it. It's as though the judge is not doing your job for you, right? It is your arena. You have to be the one to own it, pretty much. Now, so how do you ask a question? For example, you want to know words like, oh, what? Because of you have to keep it close-ended, right? Don't make it open-ended when it comes to cross-examination. You want a yes or no. You want an affirmative answer or one negative, right? So for example, a car broke down, or rather, it's a case of armed robbery. So those guys set out with guns, but they were toy guns. Set out with toy guns, and then they told a lady to come out of her car. They took the car, and then they went away. They didn't hurt her, and then it's not a question of fine. The matter is not in court. So what do you want to ask this person? So you can say stuff like, you were in possession of 2 guns, correct? Now, when you say correct, it's for him to say yes, I was, or I wasn't. When you start saying things like, can you tell this court whether you came to that place with 2 guns? Is that telling you a story? Well, what happened is this. I was with my friend on XYZ date. We proceeded to this place. I don't have a gun with me at the time. So you don't want that narrative, because I mean you are allowing him the second chance as telling a story. Bear in mind that his first chance was during examination in chief. By giving him another room to improve or amplify it, that should not be the case. You've already heard his testimony. It's your chance to now see how you can. If you feel strongly that you want to impeach, or sort of like alter that testimony because you feel like there are a lot of untruths in it, then that is when you have to ask those questions. So you're like, correct, you were with two guns. He will say, so he might say, well, I was not with 2 guns. I suppose you're not supposed to specify you were with 2 objects. He says, well, I was with 2 objects. Then you say, those 2 objects, were they guns? So you're looking for what's like where, what, which. Yeah, so which of you came to which so you want to avoid even that word which is a bit problematic. You say which of you shot. You will say, well, I do not know who shot, but rather if you're saying you shot this person on so day, it either tells you yes or no. The only time you want to use things like which or whatever, what is it, when you want to suggest it, when you want to suggest to the witness. So for example, you get to a point where there are testimonies that there are things you want to reserve for final written addresses. So what I always advise is suggest it to a witness and suggest the answer to the witness. So for example, this is a real life matter that happened sometime last month. So before I say what I'm about to say as the scenario, please don't bear one thing in mind, because I'm about to employ that device, which is start out strong with your best questions. Okay, don't reserve things for the latter. Start strong with your very strong and with your positive and very thought-provoking or captivating, or you feel like your strong cases or your strong questions, put them forward. So for example, let's say we're dealing with the case where we're dealing with the case of delivery of goods, and then the guideline says, well, for something to be delivery of goods, once I make a first attempt at delivery, I'm deemed to have delivered, or made as in that to deliver I need to make 2 attempts. So it now came down to what is the meaning of attempt, right? So you're in court now, and I'm asking the witness, okay, at the very first go, maybe I first greet him and all that, and then straight about I'm like, on XYZ date, a delivery attempt was made at your house, and then he says, well, he said yes, and I said, on XYZ date, another attempt was made at you also day. He now gets the sense of what I'm trying to say, and wants to go back on the first one, saying, well, the very first one, I won't call it an attempt. He said, I won't call it an attempt because the person set out, but I told the person that I was not going to have to be around, and the person said, okay, we bring it the following day. So because the person had said, okay, you bring it the following day, he's not saying that in itself was not an attempt. Again, so I asked him, I suggest to you that on the very first day where you received that phone call and also an SMS, that was the first attempt at delivery. But because of but at your own instance, the delivery agent was not able to deliver. I suggested that that was the case, but you disagree, correct? He looked at me amused, and then he said, I disagree. Obviously, he was going to disagree. So, but I had to suggest it to him for him to tell me he disagrees, rather than using the word I put it to you. Now, when you use the word I put it to you, it's not a question. You are not getting anything in response. I just say, I put it to you that the person delivered it twice. That will not help you in your final written address. But when you use I suggest to you, it's a question and you got an answer in the negative. You were even suggesting the negative answer and you received same. It helps you now say what it does in the mindset of the judge when he's saying your written address is that if you now want to build a written address, you are saying that this question was asked to this witness, whereby it was suggested to him that attempts were made twice, and that and whether he disagrees, which he said he disagreed. What is an attempt? You define what an attempt is. So it makes things in perspective. But when you say, I put it to you that this thing happened, it's going to be very awkward to now go to your written address and say, and I put it to him that it doesn't sit well really. Yeah, but you have to keep this in the question and answer form as much as you can, right? So I've said something about positivity, right? Keep your best questions forward. Don't try to keep them in the middle, because you never can tell how questions go. I've also said that, bear in mind, it's not every time you need to cross-examine. You are even advised, before you cross-examine, think, well, must I? It's not everybody that you need to cross-examine. Yeah? So it's not like you are going to be less of a smart lawyer because you choose not to cross-examine someone. You have to be sure, okay, fine, these are already my objectives. I'm going to ask these questions based on this testimony, which I feel are various with my objectives. And because I have a full idea of the factual circumstances, I'm going to ask those questions. Bear in mind, ask questions that most likely you already have an answer to, or questions that you can control. If you cannot control that witness by virtue of the fact that the person is really ready to go head to head with you, think closely about it. Because the person, if you don't know how to control the questions, keeping it close secreted, the person could start telling a story. And once that discovered in court is judges sometimes will always want the person to keep talking. So for example, you ask a question, the question is not clear, and the question has told you, the witness has answered you yes, but he wants to explain. Because your question was not clear, you have to say, no, let me explain. So only the questions that are clear, your questions must be clear. So I just say, no, yes, that question was very clear. They just want to repeat it to him. The question is very clear. What was the time? Or the question is, did you receive an SMS? That question is very direct. It's not beating around the bush. So some people are making it too windy. It's too windy. Even the judge is lost. And also have your eyes on the judge as well. Not be too focused on the person that you're asking questions. Focus on the judge. You have to be sure that the judge is following you as you go, right? So, like I said, so there also things like silent cross-examination techniques, and that's the offshoot of what I've been saying so far. So, for example, like I said, you will not cross-examine. So somebody comes to court with their own tactics, saying that, you know what, we do it here in Nigeria a lot. I believe all over the world too. So you have told you have done your pre-trial with your client or your witness, and you're saying he's going to ask you this question. Don't worry, it's do what you say, and then we now get to court. But as far as I'm concerned, important witness, and what the person is saying in his story, the person is all over the plan, the person is the witness from the box. After the person did his exemption in chief, I was convinced that person is sent to come and destroy my life. I already have a feeling that this person was come and destroy my case. And I looked at my chances. What are the odds if I do not examine this person now? After all, these guys, they have the opportunity of calling a star witness who I'm very interested in, by virtue of the fact that a lot of factual issues that we have joint issues on. I'm going to try to examine that one rather than this person. This person is going to injure my case. I sense it strongly. When it's not time to examine, I can also say, Your Lordship, I do not have any question for this witness. As simple as that. I'm sure they'll be like, after all our preparations throughout the night, this guy is saying, don't have any question for me. Oh, is there something that he knows that I don't know? Everything is a game, right? But then be very careful about this thing. If you want to employ the silent, be very sure that that witness is not someone that has joined material issues with you, because in our own adjudicatory system, we're in a world where, or we're in a practice where, if you do not cross-examine on material issues, the court will not allow you to raise it in your written address. You'll be deemed to have considered that point. So be very careful, right? So the silent technique has qualifications, and that one I just mentioned now. If there are material issues, and that's the case of Tabansi versus Tabansi, is a 2017 case decided in the Supreme Court. If you're not too sure of, of whether it is a material issue or not, I mean, it's sometimes just ask a few questions. But if it's on material issues, you don't want to employ the silent technique on material issues. You don't want to do that, right? So let me try to just maybe flip it a bit to rebuttals. So just as you have it for rebuttals, there's rebuttals. Sometimes some people allow for sorry rebuttals. The thing with rebuttals is sometimes it could be on point of law. They could say, fine, rebut to this issue, but then on point of law. It could be on factual issues, or maybe and then on point of law. So just the like a measure of two. But let's say you're not dealing with a rebuttal and then on a point of law. It still goes back to the fact that you already had an objective. The objective being that you want to sell out an idea. You want to sell out a proposition that you believe strongly in. If the person has given a response, you are given the opportunity now to come and say, okay, you know what, I'm going to punctuate on X, Y basis. Now, in trying to puncture, you are trying to fulfill two things: your objective, and to also show that indeed your objective is more superior to this particular point. So it's two things. I'm selling to you my objective, and then I'm begging you not to buy their objective. So it's two things. And the reason why it should not buy that objective is because it has a lot of loopholes, right? So if something has a lot of loopholes, it's leaving you with only one option, the better option, which is mine, right? So that one becomes the alternative for gun. It's an economic term, but if you get the point, right? So you have a chance to report out, applying the same principle, really. You want to still work with the 80-20. You know full well that when you canvas your own point as to, let's say, a proposition, somebody is going to come back to you with his own proposition. You bear in mind on the flip side that it's like a coin. There are two sides to it. Now, you want your own coin to, the side of your coin to be what is going to win the day, right? So you make it strong enough, and you also anticipate what's on the other side. Now, in playing the devil's advocate, you anticipate, let's say, to run, that narrative must continue, because if there's a crack in the narrative, it affects the outcome. Yeah. So I want to pause it to take questions quickly. If you have any questions specific, then I can address it in real time. Thank you very much for having me.
Thank you, Obed, for that. Thank you. I'm sure that we learned a lot from what he shared. Please ask your questions. You can just unmute yourself and ask, or you can type it.
Good afternoon, everyone.
Good afternoon, Janet.
Please, sir, could you please explain a little bit more on how the 80-20 rule applies to what you explained? I did not really get that.
Okay, let me quickly do that. Thanks for your question. So this is what I'm saying, yeah? Margin for error could be 20%, it's fine. And 80% gives you an A for the most part in different parts of the world, right? So you set out to, that's why I said, before you do a cross-examination or anything really set out on a debate, you want to have a strategy. So I'm trying to work you out on your strategy. So in your case management, you have an objective, or what we call an initial evaluation of the matter. And then in that evaluation of the matter, you are doing a case management as to how you intend to start. You foresee the end. In foreseeing the end, you are able to even prepare your written address, your draft written address from your objectives. I'm not saying at the point where you get to trial, I mean, when you've already done all your you've checked your admissibilities, the admissibilities of your documents, everything is sorted, number of witnesses that you need, and the testimony that they have to give, everything is sorted. When you put it to trial, you're supposed to ensure that everything continues on that narrative. The truth is that you have a good part to play, even though people now have to tell you that in the end, witnesses determines how your case goes. We're in a part of the world where, in Nigeria, for example, we're able to sort of like ensure that the witnesses are on track in terms of how we prepare them for sessions in court. In US, for example, you cannot do that. You can't prepare a witness in the US. But then we're working within our own climb here. So in our own climb here, you have the opportunity of getting a witness ready for trial. So you have you just see that, I mean, it's easier to just modify your draft final written address, maybe just to adjust to one or two things that happen as to lapses, but it gives you, it still leaves you at an 80 or 70, and you are very convinced that most likely you are going to have judgment in your favor. So yeah.
Okay, thank you, sir. Yes, I'm here. Thank you.
Was it clear? If you have for that question, you can try to reach out to me later. I don't know.
Okay, I think that's clear. Thank you. But I just wanted to be sure. So the 80 is like what you know and you have like a control over, and 20 is what you do not?
Yeah, you can't know it also. You just have to. But then 80 still gives you like the judgment in the end anyway. So yeah.
Okay, thank you. Thank you very much.
Okay, any other question? Okay, I can see a question here from Baba Femi. Obed, can you say it?
Yes, I can say it. Okay, well, I'm flexible. I'm actually flexible. I combine a couple of techniques. So there's one where you have to be sort of aggressive. Some you just require to be soft-spoken. Some you just out there to be laying traps. You know, there's a couple of all of that stuff. So yeah, there are times where, like, for example, if you want to cross-examine a lawyer, it's tough. It's tough because they are in your head, so they're like, this one wants to be smart, so I'll be smart too. So there are times where they want to make you lose your cool, but sometimes I could just be like, witness, you're going to answer my question. That was not the question I asked you. It's my time to ask you questions, so you could not answer my questions. And sometimes I employ that just because I need to command the arena. Especially if you are going up against lawyers. I mean, lawyers who are in the witness box, they could be so tough. They could be so tough, right? So and then you be more like, I mean, two of us are in the profession together, but then you just have to just like let that just go past you, and then you're just insisting that the person should ask the question. And the reason why you're in, because you want the judge to take note of that, so that if in case anything happens like that next time, because to be like, no, answer his question, right? So you want to take charge of the room first. So the design that I adopt is I greet the witnesses, I make them feel comfortable. I ask them questions that are first not an issue. I mean, an issue, but where we can agree to always get yeses to them. So, for example, like there was a contract that was entered into between you and your friend on XYZ date, correct? He says yes. In that contract, you had agreed to certain obligations. One being that you were supposed to buy XY goods and you're going to deliver it to him on the fortnight. You say yes. Now, on the fortnight, you receive the phone call from XYZ saying that you should delay the delivery of those goods and you should bring it like on the following day, correct? You say yes. So I'm just trying to make you feel comfortable with the fact that you can answer yes to my questions. That's my strategy. So I'm making it conversational. We are flowing. And then it sort of gets to the juicy part when I'm not like trying to like crack you a bit. And then usually, and I say in paragraph 4 of your testimony, you said that you received a phone call from one Mr. Undubisi. Can you tell did you produce before the court any telephone conversation, like in terms of documentary evidence? Is it before the court? He will say, no, it's not before this court, but it's in my house. It's my house. I say, no, it's fine. It's not before this court, right? You say yes. Then I say, oh, so but you want this court to believe that there was actually that conversation, correct? You will say yes. so the thing is, but when he says yes, he thinks of the first question, the other question, that truly, but he didn't bring it to. So how do I want the court to believe? But then he said yes anyway. So he does proceed, and then I will leave that line entirely. I won't say anything again about it. I will another level of questions that I want to use to address on a particular issue, right? So bear in mind, what I'm going to address on that very first ambit is that there's no evidence before this court. That's going to be my final address. I'm going to leave it there because I don't want this to be a big confrontation between two of us, and then he now begins to give fresh testimony that the court may want to now consider. So I'll leave it there. No issue. I'll go to another area of questions that I want to ask pertaining to another issue. Just to keep it easy. Except when sometimes witnesses want to provoke you, but you have to keep your calm, but you have to ensure that you're dominant. You have to dominate that system, because some judges will give you 20 minutes to cross-examine. Some will tell you that you have those 15 minutes. And sometimes the rules of court tells you the number of minutes you have. So, I mean, that's what we are in right now, right? But then I think that question also has, so that's my style really. I'm smooth. My style is smooth. I'm just smooth, right? So secondly, please, when you have a narrative prepared, must you stick rigidly, or do you think it's okay to be flexible and deviate from your story? You can't deviate from your story. I'm very sorry, you can't. What story else? You can only have one story from the very get-go. Is that story that you use to build your case management. If during trial that story is fumbled or is messed up, you've lost the case. It's as simple as that. You can't be flexible around it anymore. You've lost that case. That case is been blown out of the waters. I'm very sorry. You may have to start looking at how to now salvage your case on appeal. That's all. Now, sir, is it right for a witness to be cross-examined on a previous statement in writing made by him without that writing shown to him? Sorry, is it right for a witness to be cross-examined on a previous statement writing made by him? Yeah, sure. Why not? You can cross-examine him so long as the documents are already front-loaded. He's presumed to know that document. It was even tendered through him. You can ask questions on it. What people do is, just to be on the safe side and to ensure that there's no miscarriage of justice, you want to say, bring this, because also be very careful. It's very good that you try to impeach the witness. So if the idea behind that document is to impeach the credibility of that witness, then you want to show it to him and tell it to elect one of the two things, what he said earlier or what he wants to say now. And that election sort of makes a mess out of their own case, because it's not like saying one thing here, saying another thing here, or which you can even catch him on the third, being that those two things that he said were even so wrong. You get, so yeah, so it's actually okay to ask him questions off the back of the fact that he's not with the document. So long as the document was tendered through him, it is presumed that he knew those documents. It's mandatory for him anyway. So yeah. Please, can you explain more rebuttals? You said rebuttals could be on point of laws. What about fact? No, I actually said it depends on what Ruth has in stock for you guys. So it could be that the rebuttals in terms of your modalities is going to be flexible, but usually rebuttal. But if it's for Moot, rebuttals are going to be on law. So it's just more like a reply on point of law, right? But then if it's on ETP, I don't know. Well, the modality will speak for itself. It could be on fact, in terms of just address those issues within 3 minutes that have been raised in the proponent, the opponent's viewpoint. So it could not be limited to maybe fact issues, logical reason, test of logical accuracy. You get, but then if it's for a mood, it's usually just very tied to reply on a point of law in itself, right? Okay. If you have more questions, I think Ruth, I think I've answered the questions.
Yes, you have. Thank you so much.
Good afternoon. Concerning your stance on inductive and then deductive reasoning, that is from the special to the general presumption, and then the general to the special presumption. You made mention of inductive logic or the reasoning being fallacious. That is fallacy. Now, my question is on what instance or what parties can actually make use of both the inductive and then the deductive logic or the reasoning? Is it only pertaining to the bench, the bar, or subject to the fact and circumstance of the case?
Are you asking who can make use of inductive or deductive? The people who are pushing the arguments ordinarily supposed to use deductive reasoning, is more of premise A, premise B, and a conclusion. So your premise A said all men are good. Olu is a man, therefore Olu is good. So all men are, Olu is, in other words, you can conclude. So it's moving from a general to a specific. That's usually a better way to argue, really, because it's deductive, rather than just saying Olu is a man, all men are good. I mean, Olu is a man, but all men may not be good. You guys, so you can't flow. It's not advised that you flow from a specific to go and make it. That's what they call the fallacy of hasty generalization. So you have to be careful about it, right? So if I spot a fallacy of hasty generalization in your argument, I'm going to call you out on it in your rebuttal. Yeah, I'm going to call you out on it, and you are going to lose points for it, because my reason is going to be superior to yours in terms of that particular point. And then if you have used it on 3 different cadres, I'm going to tell them to disregard all cadres you used it, because you were just being, that was just fallacious. It's an error in reasoning. And if they agree with me, then why not? You are going to lose points on those 3 cadres, and to your disadvantage. So yeah, anybody can use it. The judge uses it in terms of their own judicial reasoning. Lawyers use it in terms of legal reasoning as well.
Okay. Thank you. For the next session, there are certain things I want to point out from what he said, and I want us to take note of it. It's something I observed in the last year's debate and moot court competition. Okay, the first is, in cross-examination, please envisage the outcome of what you want the person that you're asking the question to give. That's envisage the outcome of your questioning. There was something he said, that there are times where there is a witness that did not in any way hurt your case. In fact, he helped your case. You must not cross-examine him. But just like he pointed out, be very sure that he did not say anything while giving his evidence in chief or in his documents that were front-loaded that it's hurtful to your case. You have to be very sure of that, because anything in his evidence that was not cross-examined to put a hole on it, that's to puncture that particular evidence, if you allow it in the final address, it will be that a smart lawyer on the other side will use it against you. Okay, and even I remember last year's okay, let me let that slide, but you get the point I'm trying to make. So where a witness, his evidence did not in any way affect your case, you may just not cross-examine him. And then there are times where this thing happens with expert witnesses, where they are sound and all that. You may not need to cross-examine them on the substantive issue in the case. Your cross-examination could come in form of you're trying to puncture their credibility. That's what your cross-examination should focus on. In cases, this is an example of how you can cross-examine in cases where the witness is already sound and his evidence with respect to the matter was sound. So all you may need to do, just 1 or 2 questions to puncture his credibility in any way, if there is room for that anyway. Do you get? I just want to point out some of these things. Then another thing is, sometimes I've seen it happen in practice, and I've seen it happen in mooting. There is this excitement you get when the witness is answering the questions that you want the person to answer. For example, Obed, Obed's tactics is actually the style I also use in cross-examination. I'm usually calm, start with general questions, that, you know, just have positive answer, yes, as questions that you already know that it's positive and the person knows that it's positive. It's more like you're trying to win the person's trust, let the person relax with you, and then you just quietly start digging the hole with other questions till the person falls into the trap. And remember, close-ended questions as much as possible. Now, when there are times where the person just answers a particular question gives the answer that you want, please don't fall into that temptation of overflogging it or explaining it. Once the witness has given the answer that you want, quickly move to the next question. Know when, just I don't know how to explain this thing and make sure that we get it. This is especially for those that would want to have a career in litigation. Know when to stop. Know when to stop. For example, before you cross-examine any witness, when a witness is giving his testimony, of course, you should have read his statement on oath. If it's a civil matter, you should have read his statement on oath, and you know, you just know what you want to ask him. Once you get that thing, just stop. Don't overkill it. I've seen, even last year and in practice. So I don't want to have a career in litigation, or I'm not particularly pursuing a career in litigation, but I needed to have courtroom experiences, and I gathered a number or two of such. One of the things my senior advised, or I learned from seniors, is please, once you've gotten what you want, that's why at the beginning or before you start cross-examination, know what you want to have at the end of the day. And once you get it, once the person has given an answer, you can always adumbrate during your final written address. Just make sure that the judge noted the answer. Make sure that the judge noted the answer. That's why Obed said something, that when your cross-examination, actually, it is, let your eyes be on the judge. Or let's say in HJIUF competitions, like last year anyway, the Moot court competition, the final round was a physical moot. So at that, just make sure that the judge noted that thing. In practice, let your eyes be on the courts, because it's actually the courts. If you're having a beautiful cross-examination and the courts, you've lost the court at some point, you're actually wasting your time. Okay, and one of the things that make a court lose you, or you losing a court, not just in moot courts competitions or in mooting, but also in debating too, it's when the thing has gone on for too long. When something has gone on for too long, please avoid verbosity. Avoid verbosity. It would make you lose your audience very quickly. And in this case, your audience is the court. One other thing with respect to rebuttals, you know, the next competition, or the competition at hand now, it's the debate competition. That's the first. I would say this for rebuttals. So if you're making a rebuttal for particularly the debate competition, because not everything in this debate competition would be law, you can make your rebuttals based on that sponsor the person's facts. You know, particularly, I would encourage you, just look out for when the person has made a hasty generalization. That's a good, that's a good avenue for a rebuttal. That's when the person has used a specific parameter to make a general conclusion. That's a very, very key avenue for rebuttal. So you see why, in as much as rebuttals have a lot to do with thinking on your feet at that time. Okay, so you can also make rebuttals based on logic. I think Obed already talked about that. And then you can also make an emotional rebuttal. I think Daniel did a little of that yesterday.